La Cour.
Please be seated. The sitting is open. The court meets this afternoon to resume hearing the first round of oral argument of Venezuela on the merits in the case concerning the arbitral award of the 3rd of October, 1899, Guyana versus Venezuela. I now invite Professor Danai Azaria to address the court. You have the floor, madam.
Mr. President, honorable judges, it is an honor and a privilege for me to appear before you on behalf of the Bolivarian Republic of Venezuela. Guyana asks this court to establish that the 1899 arbitral award is valid and binding. This request faces an obstacle. As Professor Benguet demonstrated this morning, the 1966 Geneva Agreement has superseded whatever may have been the previous legal situation. Professor Zimmerman then showed that the Geneva Agreement requires the parties to reach a mutually satisfactory solution to settle the border controversy. What the court will hear this afternoon is why the parties to the Geneva Agreement agreed to change the legal framework for solving their territorial controversy. In my presentation, I will refer to the circumstances that surrounded the conclusion of the 1897 Washington Treaty, the issuance of the 1899 award, and Venezuela's conduct after the 1899 award. I will be followed by Professors Palchetti and Tams, who will discuss why the award was invalid, and then Professor Touvenon will show that Venezuela did not waive its right to invoke the award's invalidity. Mr. President, honorable judges, the conduct of a state, its action or silence, must be interpreted against the factual circumstances in which that conduct occurs. This is the methodology of this court and the methodology of the International Law Commission. In the present situation, 4 distinct factors must be considered and must be given weight. First, the factual realities that existed in Latin America and in Venezuela in particular at the end of the 19th century and the beginning of the 20th century. Second, the application in Latin America during that period of the Monroe Doctrine. Third, the military activities of several colonial powers, and especially of Great Britain in that region. And fourth, the fact that the 2 states whose conduct is relevant in the present situation were, on the one hand, Great Britain, a major colonial power and a military superpower of the world at the time when the events took place, and on the other hand, Venezuela, a war-torn Latin American developing country. During the late 19th century and the early 20th century, Venezuela had seen parts of her territory being annexed by Great Britain and was in fear of further annexation and military action by Great Britain, a pattern of conduct on the part of the imperial power that was regrettably common in Latin America and other parts of the world. Venezuela was also the victim of force by major European colonial powers, including Great Britain. And Guyana does not dispute these facts. These events made Venezuela deeply apprehensive of her neighbors' relentless hunger for more land. Her fear was well-founded. The evidence supporting this state of affairs is overwhelming. And in particular, I will begin with the facts that led to the 1897 treaty and the 1899 award. The voluminous evidence provided in the written submissions by Guyana and Venezuela shows that in the years prior to the negotiations that led to the 1897 Washington Treaty, Great Britain was expanding over Venezuela's land and posed an existential threat to Venezuela. But let us focus on the circumstances immediately preceding the start of negotiations between Great Britain and the United States that led to for the arbitration that would resolve the boundary dispute between Great Britain and Venezuela. Now, these negotiations began in January 1896. The evidence shows that Great Britain and the United States of America were both well aware that immediately prior to negotiations, Great Britain's conduct put Venezuela in duress and vitiated its free will. I will offer two examples. First, in July 1895, less than 6 months from the beginning of negotiations, the US Secretary of State, Mr. Olney, sent a letter to Mr. Bayard intended for the British Prime Minister, Lord Salisbury. The letter is in tab 36 of your folders. In his letter, Olney asserted the Monroe Doctrine, but also explained that the conduct of Great Britain towards Venezuela, and I quote, in effect deprives Venezuela of her agency, of her free agency, and puts her under virtual duress. My learned friend, Mr. Eichler, relied on Monday on this very letter, but he conveniently forgot to mention this part, or perhaps deliberately avoided to point it out. Perhaps this is because Guyana's counsel prefers this court to believe that in the 19th century, Venezuela and Great Britain were two countries on equal footing, exchanging various proposals for the delimitation of the boundary, as he puts it. Second, only 3 months after Olney's letter to Lord Salisbury sent an ultimatum to Venezuela's president, President Crespo. He demanded reparation for the brief arrest by Venezuela of British policemen at Uruan, an area that both Venezuela and Britain claimed. This ultimatum threatening force had been publicly reported. On 20 October, the New York Herald reported that Great Britain had already sent Maxim guns to the border with Venezuela. This is only 1 month before the beginning of negotiations that led to the Washington Treaty. Contrary to the misleading narrative that has been put forward by Guyana's counsel, Olney's letter to Lord Salisbury and Great Britain's ultimatum to Venezuela proved that the United States and Great Britain knew that seeking help from the United States was the only way for Venezuela to stop Britain's expansion over her territory. And they also knew that Venezuela lacked free will. Guyana's counsel has also suggested before you that the United States was Venezuela's greatest champion. But the widely known historical facts simply do not support this narrative. It is because of Britain's defiance of the Monroe Doctrine in writing by Lord Salisbury himself that US President Cleveland invoked in the US Congress in December 1895 the Monroe Doctrine against the expansion of British Guyana and proposed the Boundary Commission, not because of some humanitarian benevolence and friendship towards Venezuela, as Guyana's counsel asks this court to believe. This reality also explains why the United States was not concerned about Venezuela's interests during the negotiations for the arbitration between Great Britain and Venezuela. Once Great Britain participated in the negotiations with the US, and no longer mentioned.
Council, could you slow down a bit?
Of course.
Interpreters
Thank
are
you.
having a problem.
Thank you, Mr. President. Once Great Britain participated in the negotiations with the United States and no longer mentioned or defied the Monroe Doctrine, the relationship between Great Britain and the US had been smoothed over. I now turn to the period during negotiations that led to the Washington Treaty of 2nd of February 1897. The process of negotiations began in January 1896. It was the United States of America and Great Britain, not Venezuela, that negotiated this treaty. To be clear, this is a treaty that would establish the arbitral tribunal to settle the disputed territorial boundary of Great Britain and Venezuela. Venezuela was not included. During these negotiations, Great Britain and the United States, between Great Britain and the United States, Venezuela continued to be in great fear of Great Britain and reported British aggression. There is ample evidence in the written submissions. I will provide 4 examples from the period between August and December 1896, the final months of the negotiations. These and other documents in the written submissions show the despair of senior Venezuelan officials about British aggression. First, on the 18th of August, 1896, Venezuela's ambassador to the United States, Mr. Andrade, informed Mr. Olney, the US Secretary of State, that during negotiations, there had been a new aggression by Great Britain. Second, a few months later, on the 5th of December, 1896, Mr. Andrade sent another letter to Mr. Olney, informing him about Venezuela's objectives vis-à-vis the negotiations. You can see the letter in tab 55 of your folders. Mr. Andrade stated, and I quote, "Venezuela expects treaty or by diplomatic notes through you, agreement to prevent aggression or unfriendly acts." Counsel for Guyana relied on this very letter, including this extract on Monday, to promote the narrative that Venezuela was so determined to sign the Washington Treaty. But he ignored to place emphasis on the critical detail in this letter. Venezuela's aim was to prevent aggression against her. Third, a few days later in December 1896, Venezuela's Minister of Foreign Affairs, Mr. Rojas, informed the Venezuelan ambassador in the United States, Mr. Andrade, of Venezuela's decision to accept, in principle, the draft text submitted to her. You can see this letter in tab 37 of your folders. His words are haunting. He wrote, and I quote, "Although the project of the treaty raises serious difficulties, the government, taking into consideration, on the one hand, what it owes to the United States of America, and on the other, the dangerous consequences of the abandonment in which the refusal would place Venezuela, has decided to accept, not simply and flatly, but with certain modifications, the proposed articles, in whose preparation, unfortunately, it has not been included." This letter confirms that Venezuela was fully aware that the only way to stop Great Britain's expansionist ambitions and aggression was the support of the United States. If this support were to be withdrawn, dangerous consequences would inevitably follow. Fourth, Venezuela requested that a change be made to the draft text so that Venezuelan arbitrators would sit on the tribunal. Olney replied that the matter was closed between Great Britain and the United States. You can see the text, including this sentence, in tab 56 of your folders. And indeed, Guyana's counsel even referred to this very document on Monday. But again, he avoided to mention that in the end of this very document, only reprimanded Venezuela that her attitude, namely her request that the treaty provided that Venezuelan nationals would sit as arbitrators, was offensive and tended to block all negotiations. The necessary implication of this warning by the United States, an implication that Venezuela understood clearly, was that the United States would withdraw its support should Venezuela insist on her proposed quote-unquote offensive amendments. Dangerous consequences would follow. Great Britain would use force and Venezuela would lose more land. Guyana does not dispute the threat of British military activity against Venezuela. Instead, it claims brazenly in its reply that these dangerous consequences were apparently unspecified, and counsel for Guyana alluded to this on Monday. Yet the extensive factual record shows that these dangerous consequences were well known to Venezuela, and they were very specific. First, Britain's expansion over Venezuela's land was one of these dangerous consequences. Guyana itself relies on several communications by Venezuelan officials to US senior officials in the years immediately prior to the negotiations, which prove Venezuela's profound apprehension about British claims of apparently indefinite annexation. Indeed, Guyana's counsel again relied on one of these documents on Monday, but he did not place emphasis again on the critical detail. In 1888, the Venezuelan chargé d'affaires in the United States sent a letter to the US president asking for help, and yes, they were asking for help, in order to prevent Great Britain's attempted acts of spoliation, encroachment, and appropriation to herself of very nearly 1/3 of our whole republic. Second, aggression by Great Britain was the other dangerous consequence. An ultimatum threatening force had been sent by Great Britain to Venezuela only 1 month before the negotiations began. And British aggressions were being reported even during the negotiations. Mr. President, this is the nefarious historical background, the structural coercion background of the 1897 Washington Treaty between Great Britain and Venezuela, which can hardly be called an agreement. Yet the injustices that Venezuela suffered did not stop there, Mr. President. They continued during the arbitration. The Arbitral Tribunal did not merely rely on the unjust and invalid Washington Treaty. It also opted to manifestly exceed its power. These issues will be discussed by Professors Palchetti and Tams. I will focus on the circumstances surrounding Venezuela's behavior after the arbitral award was issued. Now, once the invalid award was issued, the picture remained the same. Might makes right, but with an additional dystopian twist. Venezuela was now expected to adhere to international justice, a justice that was really a farce, as Professors Palchetti and Tams will consider. It is essential to point out that Venezuela did not have evidence to challenge the award's invalidity on the ground that the tribunal manifestly exceeded its power. Evidence came into her possession, as Professor Tribunal will point out, only in the second half of the 20th century. But the record also shows that in the meantime, Venezuela had no choice but to endure the award. For one thing, when the award was issued, it was publicly reported that the United States will force Venezuela to accept the verdict and that it will act appropriately if there are problems with the enforcement of that decision. Further, between 1899, when the award was issued, and 1903, Venezuela was embroiled in a civil war. During this period, Venezuela lacked a fully operational government and administration. These circumstances must be considered when assessing Venezuela's conduct, as the court has rightly noted in Somalia versus Kenya. The British Foreign Office was indeed well aware of Venezuela's vulnerable situation. For instance, on the 19th of March 1900, Mr. Palacio, Venezuela's Minister of Foreign Affairs, sent a letter to the British Foreign Office informing that the Venezuelan government was facing difficulties in connection with public order. So what was the response of Great Britain to this letter? Well, Britain informed Venezuela that it would unilaterally conduct the demarcation. And then, proceeding alone, it erected parts of the boundary in October that same year. The report of the Venezuelan experts that has been submitted by Guyana itself describes vividly and clearly these facts. Faced with this clear pressure and the fear of losing more land, at a particularly vulnerable moment during the civil war, Venezuela had no choice but to send the demarcation commission. Venezuela's fear was further proven by a report of Venezuela's former Minister of Foreign Affairs, Rafael Cejas, on the 4th of May, 1900, who points out in the first page of his report that any challenge of the award by Venezuela would highly likely lead to further annexation by Great Britain. Now, Venezuela's apprehension vis-à-vis Great Britain was confirmed, unfortunately, by subsequent events. Between 1902 and 1903, Great Britain, along with Germany and Italy, blockaded and bombed Venezuela's ports. The blockade ended only when Venezuela was forcibly defeated. As a condition to raise the blockade, Great Britain imposed to Venezuela the payment of £5,500 cash and the signature of the 1903 protocol, according to which the rest of the claims, British claims, would be submitted to arbitration. In those arbitration proceedings, Counsel for Venezuela demonstrated the vast inequality of strength between Great Britain and Venezuela. You can find the pertinent extract of his speech in tab 38 of your folders. He stated, and I quote, "Great Britain is one of the most powerful nations on the earth, and she was confronting one of the weakest nations, then torn by internal commotion and needing every particle of strength she possessed and every dollar of revenue she could collect at her ports to maintain her own existence. This disparity in strength is clearly shown," he continued, "in the Statesman's Yearbook for 1903, an accepted authority in such matters, which details the great and efficient standing army of Great Britain, as well as her supreme control of the seas by her vast navy, while it reports that the army of Venezuela consists of 9,000 men and her navy of 3 steamers, 2 sailing boats, and some small gunboats. Such was the documented vast inequality between Venezuela and Great Britain. Against this background, the forcible defeat of Venezuela unequivocally communicated a powerful message to the war-torn young republic, as it would to any reasonable observer. If Great Britain was capable and willing to use force to collect £5,500 in cash and to submit the rest of its claims to arbitration, then surely Great Britain was able and willing to go so far, if not further, had Venezuela challenged the 1899 award, which concerned boundaries, a matter of the greatest importance for the British Empire. Now, Guyana's counsel endeavored to give the impression on Monday that Venezuela enthusiastically insisted in abiding by the 1905 demarcation. Yet the facts show that in the face of the indisputably tremendous military disparity between Great Britain and Venezuela, and against the background of repeated aggressions and threats of annexation that Venezuela had endured, she was left with no option but to endure the award for years as a safeguard, as a shield against the expansive ambitions of the British Empire. Or, as the Venezuelan experts have put it, in order to prevent further troubles. That Venezuela's apprehension was substantiated is further borne out by Great Britain's continued territorial ambitions following the boundary demarcation. In 1906, Great Britain requested alterations to the boundary line that had been demarcated in 1905, pursuant to the award. Venezuela's Minister of Foreign Affairs responded that the proposed modification by Great Britain amounts to a veritable cession of territory, and it is for this very reason that he also maintained in writing in his response the need to not depart from the 1905 demarcation. Guyana's counsel mentioned this very response on Monday, but conveniently avoided to mention this significant detail. Thus, this uncontested and well-documented sequence of threats and aggressions prior to the Washington Treaty and after the 1899 award instilled a well-founded fear in Venezuela, which remained a critical factor that determined Venezuela's conduct for decades vis-à-vis this award. Mr. President, honorable judges, I turn to my conclusions. Indeed, the inescapable conclusions. Any objective observer must consider these factual circumstances in the late 19th century and the early 20th century, prior and during the negotiations of the Washington Treaty, and after the issuance of the invalid 1899 award, in order to understand Venezuela's conduct. There is not only overwhelming evidence of Venezuela's fear as to Great Britain's attitude towards her during this period. Rather, there is also overwhelming evidence that Venezuela's fear was well-founded and that she only was able to obtain evidence that the award was invalid in the second half of the 20th century. It is these overall factual circumstances of the case brought by Guyana, Mr. President, that simply do not allow the interpretation that Venezuela ever renounced its right to invoke the invalidity of the award. Venezuela was in a position to challenge the award when she obtained evidence of its invalidity. That time coincided with a period of decolonization, which enabled Venezuela to challenge the award through peaceful means and negotiations. These negotiations led to the Geneva Agreement, which has superseded an unjust and invalid award and has set the legal framework for the parties to it to solve their border controversy by reaching a mutually satisfactory solution. I thank you indeed for your kind attention and request you to call to the podium Professor Pachetti.
I thank Professor Azaria for her statement. I now give the floor to Professor Paolo Pachetti. Sir, you have the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Bolivarian Republic of Venezuela. Guyana instituted these proceedings asking the court to judge and declare that the 1899 award is valid and binding. As Professor Mbenge established this morning, there is a problem with that request. Whether the award is valid or not is irrelevant, and this has been so since the conclusion of the Geneva Agreement. Despite this, Venezuela will deal with the question of the award's invalidity to contribute to better understanding the reasons that led the parties to agree on a different legal framework for settling their territorial controversy. This will also allow Venezuela to rebut Guyana's false allegations concerning the award. Venezuela's historical position is that the award is invalid because of the invalidity of the 1897 arbitration treaty, because of a lack of reasons in the award, and because of excess of powers. In the next 40 minutes, I will present Venezuela's historical position concerning the first two grounds of invalidity. After me, Professor Tams will present the reasons why Venezuela has historically maintained that the award is invalid because of excess of power. Before addressing the grounds of invalidity of the award, let me clarify what the 1899 award represents for Venezuela and for anyone looking at the facts objectively. The history of this award is, above all, a history of great injustice. For Venezuela, it has long represented an offense to national dignity. Through it, the United States and Great Britain conducted a political transaction behind Venezuela's back. They got exactly what they wanted. As Professor Moncada said this morning, the United States achieved the vindication of the Monroe Doctrine and the recognition of its hegemony in the Western Hemisphere. Great Britain, in turn, through the award, obtained the territory of Guyana Essequibo. But doing so meant sacrificing Venezuela's legitimate rights mattered little. As Professor Azaria has just shown, Venezuela was, in any event, in no position to resist. Exposing the political transactions carried out behind Venezuela's back is central to this case. Guyana has striven in these proceedings to distort the facts in order to erase any trace of injustices suffered by Venezuela. In a complete contradiction to the facts, Guyana now casts Venezuela as the main beneficiary rather than as the victim of the Anglo-American confrontation. As you have heard on Monday, Guyana insists that it was Venezuela that requested the intervention of the United States. This is correct, but also beside the point. What matters is that the United States did not protect Venezuela's interest, pursuing its own interest instead. Guyana repeatedly referred to the role of the US Secretary of State, the US lawyers who acted as Venezuela advisors and counsel, the two US justices sitting on the tribunal. In reality, this only highlights one thing, that Venezuela was absent from the entire process. It was absent from the negotiation. It was absent from the arbitral proceedings in Paris. Guyana would have you believe that the award was grounded in law. The only evidence it provides is the fact that the parties were offered ample opportunity to present their case to the tribunal. 3 rounds of written pleadings, more than 200 hours of oral proceedings. That proves nothing. Instead of insisting on the 200 hours of oral pleadings, Guyana should explain how it is possible that it took only 6 days for the tribunal to render its decision. 200 hours of oral proceedings and 6 days for rendering of decisions. If we apply the same ratio to the present proceeding, members of the court, you should render your judgment in less than a day. Bonne chance. Guyana even pretends that the award was favorable to Venezuela. Let us be clear. Great Britain was awarded more than 90% of the Venezuelan territory it had claimed. As put by one of the British arbitrators, the outcome for Venezuela was disastrous. Mr. President, I do not intend to revisit each and every fact showcasing the injustices perpetrated at Venezuela's expense. These facts are exhaustively set out in Venezuela's written pleadings. But on one point I must insist. Whatever one thinks of the territorial rights claimed by Venezuela at the time, it is simply not credible to present the arbitration between Great Britain and Venezuela as an ordinary one. The circumstances in which the arbitration agreement was negotiated and under which the arbitral proceedings were conducted are unprecedented. They reveal the state of subjugation to which Venezuela was reduced. External observers agree on this. This is how Paul Rotter characterized this arbitration. I quote, "Beaucoup de circonstances rendaient cet arbitrage de plus singulier. Les conditions dans lesquelles le Venezuela avait consenti à se faire représenter en dehors de toute protectorat."
Many circumstances made this arbitration quite singular indeed. The conditions under which Venezuela had agreed to be represented outside of any protectorate or any regular institution by a third country are very rarely found in arbitral proceedings and reveal a quasi-colonial situation.
And this is how our contemporary observer, Monsieur de la Chanonie, who attended the Paris proceedings, presented arbitration following the Anglo-Venezuelan experience. Arbitration is, I quote, un moyen économique et assez sûr.
Arbitration is a rather cheap and certain way of quietly getting away with the plundering of small states.
Mr. President, the uncomfortable reality concerning the 1899 award is precisely this. The United States and Great Britain used arbitration to dispossess Venezuela of its legitimate rights. And today, Guyana asks the court to breathe new life into that unjust decision. Because this is what this case is about. Whether to validate an unjust decision that was made possible only by the quasi-colonial imbalance imposed on Venezuela. An unjust decision, let me reiterate this point, that in 1966, Guyana and Venezuela agreed to leave behind and replaced with an obligation to negotiate a mutually acceptable solution. Guyana's main argument is that the applicable law and the required standard of proof allow for no practical possibility of challenging the award's validity. The margins are too narrow, the standards too high. Guyana wants the court to recognize that whatever past injustice, the award is now protected by the law. Dura lex, lex, sum ius summa iuria. Guyana's argument rests on three formalistic pillars. Firstly, pacta sunt servanda and the binding character of international arbitral awards. Secondly, the principle of intertemporal law. Thirdly, burden of proof. Not one of these justifies the conclusion that Guyana seeks to draw from them. Pacta sunt servanda is sacrosanct, but it does not stand alone. The preamble of the Vienna Convention on the Law of Treaties is clear on this point. I quote, "The principle of free consent and of good faith and the pacta sunt servanda rule are universally recognized," end of quote. There is no hierarchy among the three principles. Yet free consent and good faith were systematically violated throughout the negotiation of the arbitration treaty. Nor is there any presumption of validity of an arbitral award. arbitral awards are final and binding if and only if they satisfy the conditions for their validity under international law. The 1899 award never met these conditions. On the principle of intertemporal law, I have one main observation. It concerns the general principles governing the invalidity of awards. In its attempts to foreclose any possibility of challenging the validity of the award, Guyana has twisted the principle of intertemporal law to advance several untenable propositions. It has doubted the existence in 1899 of rules providing for grounds of invalidity of awards. It has argued that at that time, an arbitral award could be nullified only if this was envisaged in the compromis. It has claimed that at the relevant time there was no obligation to state reasons. None of these propositions withstands scrutiny. Guyana's emphasis on intertemporal law is only an attempt to mask the grave irregularities committed by the arbitral tribunal. It is primarily defensive and fails at that task. Finally, I come to burden of proof. It is a fact that, given the exceptional circumstances under which the award was rendered, Venezuela and Guyana are manifestly not in the same position with regard to access to evidence. Unsurprisingly, Guyana places great emphasis on burden of proof. It insists that burden of proof is exclusively on Venezuela. It also pretends that a heightened standard of proof applies to the nullity of awards. Guyana's emphasis on burden of proof is misconceived. This court has already emphasized the need to account for the circumstances of each case. The rule that the party alleging a fact must submit the relevant evidence, as the court put it, I quote, is not an absolute rule applicable in all circumstances. There are situations where this general rule would have to be applied flexibly, end of quote. Moreover, and I quote again the court, depending on the circumstances of the case, it may be that neither party is alone in bearing the burden of proof, end of quote. This court has also recognized, I quote again, that a state that is not in a position to provide direct proof of certain facts should be allowed a more liberal recourse to inferences of fact and circumstantial evidence, end of quote. The circumstances of the present case are well known. First, Venezuela did not directly participate in the negotiation of the arbitration treaty, nor in the arbitral proceedings. It was represented, so to say, by US officials who fully controlled what happened during the negotiations and the proceedings. Consequently, Venezuela has no direct access to the relevant evidence. Second, it is the United Kingdom and the United States that held most of the documents and evidence relevant to this case. Venezuela was able to access it only to the extent that they have allowed Venezuela access. Third, to this day, and despite repeated requests by Venezuelan authorities, the United Kingdom has blocked access to the information it holds in its archives. Lastly, Guyana, the successor state to Great Britain, is in a better position to provide evidence. All the more so since Guyana did, in fact, receive documents related to the arbitration from Great Britain. In sum, there is a clear asymmetry between the parties in the access to evidence. What is more, this asymmetry is the result of deliberate choices made by the states that control the evidentiary record. Venezuela submits that in this circumstance, it cannot be alone in bearing the burden of proof. It falls to Guyana to establish its contention that the award complied with the requirement of the Washington Treaty, and in particular, that it was based on law. So far, Guyana's strongest argument on this relies on the absence of reasons in the award. As you heard on Monday, Guyana pretends that as the award does not contain any reasons, it is not possible to prove that the tribunal did not follow the instructions of the compromis. For Guyana, this is sufficient to conclude that the award is valid. This argument is hopeless. I will come back to the absence of reasons in the award later on. I turn now to the grounds of invalidity of the award, starting with the invalidity of the 1896 arbitration agreement. Venezuela and Guyana agree that at the relevant time, the invalidity of the compromis was a ground to hold an award null and void under international law. They also agree that at the relevant time, error and fraud were causes of invalidity of a treaty. But they disagree on facts. Or to be more precise, Guyana has failed to engage with the facts and evidence presented by Venezuela. In its written pleadings, Venezuela has repeatedly referred to the existence of confidential documents exchanged between the United States and Great Britain during the negotiation of the arbitration treaty, in which were never transmitted to Venezuela. These confidential documents played a fundamental role in the arbitral proceedings. On Monday, Guyana did not address these confidential documents, persisting instead in distorting reality by portraying the United States as the generous, transparent, and selfless ally that forcefully defended Venezuela's interests. Mr. President, let us examine these confidential documents and their use during the Paris proceedings. In your folder, the core materials and evidence are included. These documents prove that Venezuela was a victim of fraud, which led it to incur in an essential error. They also provide a window into the farce that was staged in Washington and in Paris during the negotiation of a treaty and the arbitration proceedings. I start with the negotiation of the 1897 treaty. The two main actors in these negotiations were the US Secretary of State, Olney, and the English ambassador in Washington, Pansifat. Both acknowledged that during the negotiations, exchanges of confidential notes and letters took place. At tab 13 of your folders, you will find a letter of Pansifat referring to strictly personal diplomatic correspondence exchange with Olney. And at tab 14, and now on the screen, you can find a letter from Olney mentioning what he refers to as, I quote, informal and private notes, none of which were regarded by me as an official character or were allowed to go onto the files of the State Department. End of quote. We do not know the content of these informal and private notes, nor do we know why Olney did not want them included in State Department files. Guyana provides no explanation for this secrecy. What we do know is that at least one of these confidential notes concerned an essential part of the treaty, namely the clause establishing that prescription during a period of 50 years makes good title. At tab 15 of your folders, you will find the text of Article 4 of the treaty. As you can see, Article 4A indicates that the period for prescription is 50 years. What it does not indicate is the critical date for calculating the 50 years. If you look instead at the clause in paragraph C, you will immediately notice that unlike in paragraph A, paragraph C indicates the critical date. That date is the date of a treaty. This discrepancy strongly suggests that the critical date under paragraph A is different from the critical date in paragraph C. If the critical date for calculating the 50 years prescription period is not the date of the treaty, 1897, what could it be? Well, it can be argued that the critical date is the one indicated in Article 3 of the treaty. I quote, "the time of the acquisition by Great Britain of the colony of British Guyana," end of quote, namely 1814. This would mean that the prescription period was the period between 1764 and 1814. And it is clear that this interpretation is not only reasonable, but it would best protect Venezuela's interests, and it would preclude the tribunal from taking into account Great Britain's conduct for assessing prescription. Similarly, the critical date could be 1850, the date on which Venezuela and Great Britain committed by treaty to not occupy the disputed territory. And this would also be a reasonable interpretation and one protecting Venezuela's interest. Mr. President, we do not need to answer this question. It only matters insofar as it shows that the confidential note exchanged between Olney and Pansiford concerned an essential part of the arbitration treaty. Great Britain and Venezuela had opposite views regarding the title justifying sovereignty over the contested territory. Venezuela placed emphasis on historical title, Great Britain on occupation and de facto control. The calculation of a prescription period was one of the core issues. Guyana does not contest this. Yet, was Venezuela informed of the contents of these confidential notes before ratifying the treaty? It was not. And there is no evidence proving that it was. However, Guyana claims that it was unlikely that the contents of the notes were unknown to Mr. Storrow. Who is Mr. Storrow? He is the US lawyer who acted as Venezuela's legal advisor during the negotiation. At tab 16 of your folders, you will find the point of view of someone who was more familiar with Storrow and his working method than Guyana's counsel are. This is a letter by Benjamin Harrison, the head of the US legal team representing Venezuela before the tribunal, sent in 1899 to another member of the US team, Malé Prévost. Harrison candidly admitted, firstly, that the Venezuelan government had no knowledge of the confidential notes. Secondly, that these notes most probably were known to Storrow, I quote, "for his relations to Mr. Olney were very confidential," end of quote. And thirdly, that, and I quote again, "it is quite possible that Mr. Storrow, knowing the impracticability of some of those he had to deal with, may have purposely left this matter a little vague," end of quote, a little vague. This letter provides clear illustration of a farce staged by the United States, a farce upon which Guyana has built its entire case. Olney is in strict contact with the Venezuelan representative, but behind the mask of a Venezuelan representative, there is Storrow, Olney's close associate. Storrow would be expected to inform the Venezuelan government, but knowing the impracticability of Venezuelan officials, he only communicates with Olney. For Guyana, there is nothing wrong with that. Venezuela was informed, Guyana argues, because it was unlikely the Venezuelan representative, Storrow, did not know. Mr. President, members of the court, what a farce, what a charade. And this is only the first act. For the second act, we must go to Paris. At tab 17 of your folders, there is an excerpt of the memorial submitted by Venezuela to the Arbitral Tribunal. As you can see, in its written pleadings, Venezuela argued that the critical date for calculating the prescription period was the date when Great Britain acquired the colony of British Guyana. Following this argument, Article 4A did not apply to the period subsequent to 1814. Clearly, neither the US lawyers defending Venezuela, Harrison, nor the Venezuelan government were aware of the content of the confidential notes. But this argument sparked serious concern in Great Britain. In 1899, British lead counsel Richard Webster wrote to the US lawyers representing Venezuela. He made it clear that the argument on the critical date for prescription was contrary to what Olney and Pansefort had agreed in their confidential notes. He also demanded that the argument be withdrawn, announcing that it was Britain's intention to present the confidential documents to a tribunal. At tab 18, you will find Webster's letter. On the same day, Pansefort wrote to Olney to convey his surprise at the argument advanced by Venezuela, mentioning that Britain would make use of the confidential notes. This letter is at tab 13 of your folder. So we have Great Britain demanding that the US lawyers representing Venezuela change their legal strategy. This alone goes against any principle of justice and decency. It must be recognized, however, that this time the US lawyers informed the government of Venezuela. At tab 19 of your folders, you have a letter expressing Venezuela's surprise. I quote, "The government of Venezuela is unable to comprehend upon what authority the British lawyers demand from those of Venezuela a relinquishment of our case," end of quote. In this and in other letters, the government of Venezuela repeatedly instructed the US lawyers representing Venezuela not to withdraw the argument. What did these lawyers do? At tab 20 of your folders, you have a clear description of what happened. Mr. President, members of the court, we are in Paris. It is 13 July 1899. Britain's lead counsel, Webster, and the US lead counsel representing Venezuela, Harrison, meet to discuss the interpretation of Article 4 of the treaty. The two men agree, I quote, "The good faith of the United States was involved in the matter," end of quote. But what good faith was that? It was the good faith of the United States vis-à-vis Great Britain, not vis-à-vis Venezuela. Webster requests again the withdrawal of the argument, but the critical date is 1814. Harrison offers no resistance. He only asks for one thing, to save appearances. He cannot formally withdraw the argument. I quote, "His client, Venezuela, would not let him make a public withdrawal," end of quote. In the end, the argument was in fact withdrawn. In an oral statement before the tribunal, Harrison candidly recognized that in light of the confidential note, the prescriptive period applied to the years after 1814. You have this statement at tab 21 of your folder. As this court can see, the first act, the negotiation, and the second act, the arbitral proceedings, are part of the same script. The only difference is that in the second act, Venezuela was informed, but the instructions given by the government of Venezuela were completely ignored. Other example of the fraud could be provided. Time does not allow me to address Great Britain's use of another piece of confidential correspondence concerning this time the 1850 agreement between itself and Venezuela. I refer you to Venezuela's written pleadings where you will find the relevant facts and evidence. evidence. Before concluding on the invalidity of the arbitration treaty, let me make one point concerning evidence. The documents you have in your folder mainly consist of a correspondence exchange between British and/or American officials involved in the negotiation of a treaty or the Paris proceedings. Venezuela obtained these documents several decades after the award was rendered. When it finally did, it immediately denounced the invalidity of the treaty and of the award. It is clear that under these circumstances, no acquiescence or loss of right can be invoked against Venezuela. And you will hear more on this from Professor Touvenin later on. I will now conclude on the invalidity treaty. The evidence before you shows, first of all, the injustice suffered by Venezuela. But it also proves that its consent to the arbitration agreement was vitiated by error and by fraud. Firstly, Venezuela was misled about the meaning of the clause on prescription set forth in Article 4 of the treaty. Secondly, the error concerned an essential part of the treaty. Thirdly, Venezuela did not contribute to this error. The correspondence between United States and Great Britain remained confidential and was not transmitted to Venezuela. Moreover, with their disloyal behavior, US lawyer representing Venezuela contributed to keeping Venezuela in the dark. Finally, the recourse to confidential notes reveals that the United States and Great Britain intentionally left Venezuela in the dark to overcome any resistance to the ratification of the treaty. This amounts to fraud. The arbitration treaty being invalid for error and fraud, only one conclusion follows. The arbitral award is itself invalid. I turn to the second ground of invalidity, the award's complete failure to state reasons. Writing in 1904, in his introduction to the Recueil des arbitrages internationaux, Louis Renaud observed, I quote, « Il importe au plus haut point que non seulement la justice soit juste, mais encore qu'elle le paraisse. » End of quote. Justice, in other words, must not only be done, it must also be seen to be done. Guyana clearly defend a different position. Guyana denies that any obligation to state reasons existed in 1899. This does not withstand scrutiny. Renault's position was not merely aspiration. It had already found expression in several general rules of procedural law. Amongst these, there was the rule establishing the obligation to state the reasons for the award. Almost a quarter of a century before the award was rendered, the Institut de droit international had already recognized the existence of this obligation. A few months before the award, the same rule was codified by the first Hague Conference. The court's case law points in the same direction. In the arbitral award made by the King of Spain case, Honduras and Nicaragua accepted that lack of reasons was a ground of invalidity at the relevant time. The court, Jura Novit Curia, decided the issue of lack of reason on that very basis. On Monday, Guyana took a rather bizarre position on the court's judgment. It argued that your judgment is not relevant since the court rendered it more than 60 years after the award. This is true, but the court was assessing the invalidity of an award rendered in 1906. Perhaps Guyana is not so sure about the applicability of the principle of intertemporal law, or perhaps it is no better argument to dismiss this precedent. Arbitral practice confirms the existence at the relevant time of an obligation to state reasons. The overwhelming majority of award rendered in this period were reasoned, some briefly, but reasoned nonetheless. On Monday, for lack of better arguments, Guyana resubmitted the list of unreasoned arbitral awards it had already presented in its reply, simply adding a few more. In its rejoinder, Guyana has already demonstrated that all these awards can be easily distinguished. And I will not burden the court by repeating what Venezuela has already demonstrated in its written pleadings. Rather, I will now move to a final observation. Mr. President, members of the court, lack of reasons is not only a self-standing ground of invalidity of award, it is also a fact that can be used to prove the tribunal excess of power. You will hear more on excess of power from Professor Thams. What I wish to place before the court now is the logical link between the two grounds. Excess of power arises when a tribunal departs from the mandate granted to it under the compromise. But how does one verify whether that mandate was respected? The answer is simple: through the tribunal reasoning. But what if the award does not state the reasons? It is enough to raise this question to understand that the tribunal decision to not state the reason was not innocent. It was not, as Guyana presents, a mere consequence of the absence of an obligation. It was a deliberate choice. And this choice was even more striking when considering the context. Just a few weeks before, the Hague Peace Conference had recognized the existence of an obligation to state the reasons. The Treaty of Washington clearly required the tribunal to render a decision based on the strict application of specified legal principles. And finally, the absence of Venezuelan arbitrators rendered even more important that the authority of a decision should rest on properly reasoned award. So what inference could be drawn from the fact that the award does not indicate, even briefly, the reasons upon which it rests? In 1899, at the Hague Peace Conference, the German delegate, Zorn, responding to Martens, the president of the Anglo-Venezuelan Tribunal, observed, I quote, "Arbitral award must be legal decision, and a legal decision without the reasons in which it is based is inconceivable," end of quote. If the tribunal did not take care to present the award as a decision based on law, a reasonable explanation is, most simply, that it was not. Indeed, the absence of reasons was the only way that the tribunal could mask the fact that its decision did not result from the application of the rules outlined in the arbitration treaty. And this concludes my presentation. I thank the members of the court for their kind attention and would ask Mr. President to give the floor to Professor Thams.
Thank Professor Paretti. I now call Professor Christian Thams to the podium. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you and a privilege to do so on behalf of Venezuela. My presentation pursues the argument set out by Professor Paretti. He has shown that the 1899 award was invalid because it was based on an invalid treaty and because it was unreasoned. I will present to you a third ground of invalidity. In rendering the award, the tribunal exceeded its powers under the Washington Agreement. In fact, it committed multiple excesses of power, approaching its task with scant respect for its mandate. And that is why the United Kingdom and Venezuela left the award behind when concluding the Geneva Agreement, an agreement that, as my colleagues have shown this morning, tasked its parties to seek a mutually acceptable solution to their long-standing controversy. On Monday, Guyana sought to defend the 1899 award. But much of this defense was rather timid. At the time you heard, arbitration was still in its infancy, un accident heureux. An obligation to give reasons was emerging, but had yet not not yet fully crystallized. It was still fine at the time, says Guyana, for arbitrators to meet with counsel during deliberations. And in any event, as the award was unreasoned, it was impossible to establish that the arbitrators had violated their mandate, and so on and so forth. Mr. President, in the face of such defensive moves, let me begin by stating clearly that the legal regime governing excessive power is not in doubt. First, it is clear that awards, including those rendered in 1899, can be challenged for excess of power. Excess of power is, as the ILC would later note, and I quote, the oldest and most universally recognized ground of nullity, end of quote. Second, it is clear, and it was clear in 1899, that excess of power can take different forms. Obviously, a tribunal exceeds its power if it decides on matters not submitted to it. But excessive power also covers instances in which a tribunal fails to pronounce on issues it must address. This is sometimes referred to as a negative excess of power. And finally, awards can be challenged where the tribunal disregards the applicable law or decides extra legem. And none of this is in dispute. Third, it is clear how excess of power is to be assessed. It needs to be asked whether a tribunal respected the terms of its mandate. In your jurisprudence, you have formulated the central proposition in terms that you see on the slide. In the performance of the task entrusted to it, the tribunal must conform to the terms by which the parties have defined this task, end of quote. And these are exactly the words used by Guyana on Monday. So conforming to the terms of the mandate, that is the test. And it is a test that requires, as the ILC put it in its work on arbitral procedure, and I quote again, it requires a careful comparison of the award with the relevant provisions of the compromis, end of quote. The compromis that is the sole basis of the tribunal's power, in our case, the Washington Agreement. Mr. President, members of the court, what does such a careful comparison reveal in our case? Venezuela submits that when rendering the 1899 award, the tribunal committed multiple excesses of power. I will highlight three of these. First, a negative excess of power. The tribunal failed to fulfill one of the tasks entrusted to it. Second, an excess of power in the obvious sense. The tribunal decided matters that were plainly outside its competence. And third, the tribunal failed to comply with its most solemn duty, the duty to render an award based on law. Mr. President, I begin with the tribunal's mandate. It was set out in Article 3 of the Washington Treaty. You see the language on the screen. And the language is clear. The parties gave the tribunal two tasks and formulated both of them in mandatory language using the verb shall. The tribunal had to first investigate and ascertain the extent of the territories belonging to the Netherlands and Spain in 1814. I'm paraphrasing and simplifying. And secondly, the tribunal had to determine the boundary line. Now, there's no doubt that the tribunal determined the boundary line. It complied with the second task, but not the first. The award is silent on titles. The tribunal does not tell the parties what it had investigated and ascertained. And on the face of it, this seems a fairly glaring negative excess of power. On Monday, Guyana sought to explain away the tribunal's failure. It suggested that ascertaining the titles was merely a prelude to the boundary decision. The tribunal really had only one task, says Guyana. It had to determine the boundary. But this does not withstand scrutiny. It does not withstand scrutiny because it misconstrues the role of the arbitrator, as it was well defined in the late 19th century. Vasco, on whose work Guyana relies, made the point very clearly, and I quote the original French. Le tribunal doit juger tout point prévu au compromis, fut-il d'avis qu'il n'y a pas lieu de l'examiner. Every point must be adjudicated, even if the tribunal considered this irrelevant. In their opinion, in the 1999 arbitral award case before this court, Judges Aguilar, Maudsley and Ranjeva put matters very clearly. Requests framed in a compromis, and I quote, lay down the terms of the difficulty, end of quote. And further, I quote again, a judge seriously fails to perform his mission whenever he decides not to answer a question, end of quote. And looking at the 1899 award, how can we escape the view that the Paris Tribunal seriously failed to perform its mission? Now, Mr. President, there are exceptions. The parties to the compromise can, of course, give the tribunal discretion. And the arbitration agreement between Guinea-Bissau and Senegal, which was at issue in the 1991 arbitral awards case, illustrates this. You see it on the slide. And you see that the tribunal in that case, like the one in the case we are discussing, had two tasks. It was to respond to two questions. But you see immediately from the highlighting that the tribunal in Guinea-Bissau, Senegal had discretion. It only had to address the second question if it responded to the first in the negative. This was said so expressly in paragraph 2, categorically, as this court observed, and it was material to the 1991 decision. This discretion is exceptional, and it is instructive how this court in 1991 approached the exception. In the 1991 judgment, this court distinguished between arbitration agreements that gave tribunals discretion, like Article 2 you still see on the slide, and, on the other hand, arbitration agreements that raised, and I quote, successive questions which are not made conditional on each other, end of quote. The clear implication is that normally tribunals have no discretion. They must address all requests put to them. Mr. President, the international practice points us to examples of special agreements that raise such successive questions which are not made conditional on each other, to use the terms again. And it makes clear that in the presence of such a mandate, tribunals have no discretion. Another arbitration involving Guinea-Bissau, not the one with Senegal, but the one with its southern neighbor, Guinea, is instructive. It was decided in 1985 on the basis of an arbitration agreement that, like in our case, tasked the tribunal to assess titles first and then to determine the boundary. And naturally, the tribunal in the Guinea-Bissau arbitration engaged with both. It addressed titles first and the boundary second. It conformed to the terms of its mandate. Mr. President, the arbitral tribunal in our case was required to do the same, and for a further reason. It could have no doubt how crucial the question of title was for the parties. Both parties made detailed submission on the question and stressed its relevance. Pas pro toto, let me take you to a passage from General Harrison's concluding argument, which is focused specifically on Article 3, defining the mandate, and the tribunal's dual task under the provision. And you see the text on the slide. I will read excerpts. Article 3, said General Harrison, introduces the Netherlands and Spain. And I quote, it does not declare simply that they, that is the arbitrators, shall find the boundary between the existing claimants, but they are to ascertain the extent of the territories belonging to, or that might lawfully be claimed by, the Netherlands or the Kingdom of Spain at the time of this acquisition, that is a reference to the year 1814. And further, Harrison still continues, this was a duty not laid upon the tribunal for nothing, and it was, and I still quote, a duty that the tribunal cannot put off manifestly. Mr. President, members of the court, in light of all this, it is clear that the tribunal could not simply ignore the first of the two tasks entrusted to it. It could not, in Harrison's terms, put off this duty, but it did, and it thereby manifestly violated its mandate. And in fact, Venezuela cannot but agree with one of the leading scholars on this dispute, Gilles Vetter, whose in-depth treatment of the dispute is instructive in many ways, and whose assessment of the award we have included at tab 50 of the judge's folder. By not fulfilling its first task, Vetter said, the tribunal had committed, and I quote, a serious dereliction of its duties, end of quote. A dereliction that, Vetter continued, and I quote, was no doubt a valid ground for a nullity claim, end of quote. Mr. President, I move on to my second point. While the tribunal ignored the first of its two tasks, it decided a further issue, which was never submitted to it. In the final section of the award, the tribunal set out the regime for free navigation on two rivers, the rivers Amacuru and Parima. Its decision on the point is quite detailed, and you see it on the slide. It occupies almost as much space as the tribunal's description of the boundary. In essence, two of the Orinoco's tributaries were to be open to shipping, subject to the payment of fees, but within complex parameters defined in the award. The details need not concern us. Yet what must concern us is that with the stroke of a pen, the tribunal turned the Amacuru and Parima rivers into internationalized watercourses. And this, incidentally, was very much what Great Britain had wanted, as is clear from Lord Russell's correspondence. Mr. President, members of the court, nothing in the Treaty of Washington had empowered the tribunal to impose a navigation regime for the Amacuru and Parima rivers. Guyana accepts that the decision on navigation finds no textual basis in Article 3, which defined the tribunal's mandate. So on the face of it, this is an obvious case of a tribunal adjudging on a matter not submitted to it. On Monday, Guyana tried to explain away the tribunal's excess of power by pointing you to Article 4, litera C of the Washington Treaty, and it tried to present the imposition of the navigation regime as an adjustment of the boundary, which it says was a proper exercise of the tribunal's discretion under that provision. But this plainly misconstrues the terms by which the parties had defined the tribunal's task. If you look at the opening words on the slide, you see that Article 4 is about rules. Those rules the tribunal had to apply, and I quote, in deciding matters submitted to it under Article 3. That is the question of the titles and the boundary. Article 4 is an applicable law clause, not a clause extending the tribunal's mandate. And litera C, on which Guyana relied, confirms this. It suggests that the tribunal exceptionally, if rules A and B have been exhausted, might resort to other considerations, but only, and I quote, in determining the boundary line, end of quote. And beyond this, litera C is very specific. It defines precisely under which circumstances the tribunal could exercise discretion, namely, and I quote again, where territory of one party is found by the tribunal to have been at the date of this treaty in the occupation of the subjects or citizens of the other party, end of quote. And then, but only then, can, and I quote, effect be given to the occupation. So we're looking at adjustments to the boundary line, territory, occupation, None of this remotely fits the navigation regime decision. To get from Rule 4, litera C, to the imposition of a detailed regime of free navigation requires a quantum leap. And perhaps it is telling that Guyana made no effort to justify the decision by reference to the terms of the Washington Treaty. Instead, it relied on a statement by counsel for Venezuela that had emphasized the tribunal's alleged discretion in applying Rule 4, litera C. But that statement is taken completely out of context. It had nothing to do with navigation. In fact, the parties did not address the issue of navigation on the Barima and Amakuru rivers. The tribunal acted entirely upon its own initiative when imposing a navigation regime. And Gilles Vetter's assessment is again helpful. Vetter did not mince words at the end of his inquiry. The decision on navigation, he said, was, and I quote, an extraordinary action ultra vires, end of quote. A blind, unauthorized excursion into an area wholly outside the conception of the draftsman of the treaty, the parties, and their counsel, end of quote. And Mr. President, to conclude on this point, it is difficult to ignore the discrepancy. The issue that the parties had argued at length, titles, is ignored by the tribunal. And on an issue that the parties did not discuss, navigation, the tribunal renders a decision with important consequences. One, dereliction of duty. One, decision ultra vires. Two manifest excesses of power that shaped this award and that render it invalid. Mr. President, I would now move on to my third and final point, which would take me about 15 to 18 minutes to develop. I can go on, of course, but I wonder whether you would prefer to have a break now. I am in your hands.
I think you should complete your pleading.
Okay, thank you, Mr. President. So I come to my third point, the third, excessive power. The tribunal was mandated to render an award based on law, but it failed in this, its most solemn duty. Instead of deciding on the basis of legal considerations, it rendered a decision based on political expediency. As put by Paul Reuter in his assessment, and I quote in French, l'arbitrage avait été rendu sur la base d'un marchandage purement politique et sans tenir autrement compte des règles fort précises énoncées à l'article 4 du compromis. End of quote. Un marchandage purement politique. This was horse trading. Horse trading explained the decision. Mr. President, Guyana on Monday sought to portray Venezuela's claims on this point as the stuff of, and I quote, theater and fiction, based on no more than one single document, the Malé-Prévost Memorandum, which Guyana suggests may not even have existed. But for all the noise it made on Monday, Guyana did not engage with the evidence. Evidence that clearly shows that in its deliberations, the tribunal was not guided by legal considerations. Now, Mr. President, in advancing this claim, Venezuela is not naive. Venezuela knows that arbitral tribunals are composed of individuals, that these individuals discuss and seek compromise. Of course they do. But equally, of course, arbitrators operate within limits. As they strive for consensus, they must respect their mandate. Compromise must be reached within the parameters of the law. It is, as Hirsch Lauterbach put it, and I quote, circumscribed by the duty to apply the existing law, end of quote. This duty binds every tribunal, and it was absolutely essential for the Paris Tribunal. This was a tribunal, and the statement that you see on the slide brings this out clearly, that had been established to substitute right for might. The parties in particular, and I quote, came to it as a great court. End of quote. In the final days of the hearings, General Harrison, from whom the words on the slide are, once more emphasized the point, insisting that the parties expected to be judged upon the principles of international law and the rules of the treaty, and not to be compounded or compromised upon suggestions of political expediency, end of quote. Mr. President, the tribunal ignored General Harrison's warning. The evidence shows that it did exactly what General Harrison had feared. It rendered a decision that sacrificed legal considerations on the altar of political expediency. I make 3 points. The first concerns the outcome of the process, the award. Professor Palchetti has spoken to this just now. This is an award without a trace of legal reasoning. The boundary is identified, a navigation regime is decreed, but it is impossible to understand what guided the tribunal in its decision. This lack of reasons is in itself, as we have shown, a reason to render the award invalid. But it is also indicative of the tribunal's decision-making process. The tribunal was unable to put on paper any legal considerations that might have guided its decision, and this is the first relevant factor. My second point, the setting. Under Article 10, the tribunal was to render its award, if possible, within 3 months. In the event, it produced its award not in 3 months, but in 6 days. 6 days. These 6 days included a weekend, during which at least one of the arbitrator, Lord Russell, was not in Paris. 6 days, Mr. President, to assess arguments, made in 3 rounds of written pleadings and 56 sessions of oral hearings. 6 days to engage with information contained in 2,600 documents filed by the parties. Mr. President, allow me to pursue briefly the point made by Professor Palchetti and his comparison. In this case, you have scheduled 4 days of hearings. The transcript and written record are a fraction of what the tribunal in Paris had before it. We can all do our maths. If the Paris tribunal took 6 days to decide after 56 days of hearings, how long will you take after 4 days? Will you convene for a quick morning session next Tuesday, and we meet again in the afternoon for the reading of the judgment? Perhaps you will. But the thought that by then, by next Tuesday, you could have weighed the arguments with the care required of an international court is absurd. Yet this is exactly how the Paris tribunal approached its task, as it rushed out its award. And given this haste, we ask, is it at all plausible to say that the tribunal had weighed the detailed legal arguments advanced by the parties? It is not plausible. There was simply no time. And this is the second relevant factor. Mr. President, my third point. How then was the decision reached? We need not remain focused on the award, its rushed nature, its silences. We have multiple accounts that describe how the tribunal identified the boundary line. Accounts that come from key protagonists, from the arbitrators and counsel, their diaries, their letters. And these accounts, of which Venezuela became aware after the publication of the Malle-Prevost Memorandum, converge on the central point. The boundary line described in the award was put forward by President Martins without any legal basis. President Martins threatened the British and American arbitrators to accept his line in separate meetings outside the tribunal's formal deliberations. And I use threatened here on purpose, because President Martins made clear that unless the two groups he approached, the British and the American arbitrators, came round to his view, he would endorse the respective other sides' claims in full. Venezuela has set out the evidence in detail in the written pleadings. Permit me to take you to 3 documents that present the views of key protagonists and offer insights into the deliberative process of the tribunal. I begin with the account given by Mr. Malé Prévost, which Guyana dismissed on Monday as a work of magical realism. In the relevant passage, Malé Prévost recounts a meeting with one of the US arbitrators, arbitrator Brewer, in the middle of the tribunal's 6-day deliberations, in which Brewer briefs Malé Prévost of what has happened during the deliberations. And I would take you to Malé Prévost's account first, and then perhaps afterwards we can see whether Guyana is right to dismiss this as the stuff of fiction. Now, this is how, according to Malé Prévost, arbitrator Brewer recounts the decision-making process. The key excerpts are on the slide. And I quote, "Martens has been to see us," that's Brewer and Fuller. "He informs us that Russell and Collins are ready to decide in favor of the Schomburg line," end of quote. "They are ready to give Great Britain the control of the main mouth of the Orinoco," end of quote. Now, Brewer and Fuller obviously considered that the line should be drawn differently, but they were faced with a threat. And you see it on the slide, and I quote, "If we insist on starting the line at the coast at the Moruca River, he, Martens, will side with the British and approve the Schomburg line as the true boundary," end of quote. So this is the prospect facing the American arbitrators, a 3-2 split decision that gives Great Britain everything. But the president points a way out. If Fuller and Brewer accept his compromise line, and I quote, "he will secure the acquiescence of Lord Russell and Lord Collins and so make the decision unanimous," end of quote. And so a deal is taking shape. A deal that gives 90% of the disputed territory to Great Britain and leaves Venezuela with the rest. A deal in which, if we believe Malé Prévost and Brewer, legal considerations play no role. Now, Guyana says this is all a fantasy of a biased old man written up decades later and I quote, "uncorroborated in any other document," end of quote. That is plainly incorrect. As for Malé Prévost's position, the memorandum confirms points he made in a private letter written in late October 1899, around 3 weeks after the award was rendered. In that letter, identified by Venezuelan researchers after the publication of the memorandum, Malé Prévost made the same core point. He said, and I quote, "the decision was forced upon our arbitrators," end of quote. But let us look at how other key players described the deliberations. Lord Russell, the British arbitrator, is one of them. On the slide, you see his account, drawn up on 7th October 1899. That is 4 days after the reading of the award in a letter to the British Prime Minister, Lord Salisbury. And again, Venezuelan researchers unearthed this after the publication of the Malé Prévost memorandum. In the letter, Lord Russell described the grievous disappointment felt by Justice Collins and himself at the attitude adopted by the president. The president said Lord Russell, and I quote, "cast about for lines of compromise," end of quote. So how did this compromise line become the boundary line imposed by the tribunal? This is Lord Russell's account. The president, and I quote, "intimated to Collins in a private interview, while urging a reduction of the British claims, that if we did not use them, he might be obliged, in order to secure adhesion of the Venezuelan arbitrators, to agree to a line which might not be just to Great Britain," end of quote. And Mr. President, you will not miss the parallels. The same threat that featured in Malé Prévost's account, in this case made against the British arbitrators. Unless they reduce their claim to fit President Martin's compromise line, Martens might be, and I quote, "obliged to agree with the US arbitrators and render an unjust decision." So the British are facing the prospect of a 3-2 split decision for Venezuela, unless they come round to Martens's compromise line. But it's not just that for what Russell's letter is helpful. Lord Russell was certain that the threats were made in both directions. He had, and I quote, no doubt President Martin spoke in an opposite sense to the Venezuelan arbitrators, and fear of possibly a much worse line was the inducement to them to assent to the award in its present shape, end of quote. Which of course is exactly what Mallet-Prévost would later recall in his memorandum. Magical realism? So how was the deal reached? If the accounts by Russell and Mallet-Prévost left any doubt, such doubt is dispelled by none other than President Martins himself. President Martins recounted what happened in his diary under the date of 3rd of October, 1899, the very date of the award. And you have excerpts on the slide and more detail at tab 54 of the folder. And from the excerpts on the slide, it becomes clear how President Martins seemed to have spent the 6 days until the award was rendered. Not, it seems, in tribunal deliberations, but in a series of meetings, private meetings, insisting that the other arbitrators accept his deal. And you see the references to that on the slide. He persistently urged Fuller. He went to Collins. He went again to Brewer. He went again to see Lord Collins, and so on. But that is not all. The excerpts on the slide confirm that President Martins did make the threats that Lord Russell and Mallet-Prévost had recounted. Martins says so expressly. As Lord Collins resists, and I quote, "I explained to him that England was not interested in forcing me over to the American side. This made him think," end of quote. And Martins's approach also gave Lord Russell pause. And it's the quote that I read to you now from the lower end of the slide. "The fear that I would go over to the American side simply pissed him off," end of quote. These are President Martin's words I would want to point out. And from the excerpts, it is also clear how seriously Martin's threats were taken. And I quote again from the bottom end of the slide. "It was clear," end of quote, said Martins, "that if the British had not agreed to my compromise, I would have joined the Americans rather than them," end of quote. And when the US arbitrators resist, they are told in no unclear terms, and you see it in the middle of the slide, I quote, that if they did not make a concession, then I would be forced à contre-cœur to side with the English, end of quote. And I ask again, magical realism, all of this? Mr. President, members of the court, anyone who cares about international arbitration might wish this was the stuff of fiction. It is not. The accounts I have taken you to paint a clear picture. They are authoritative. They come from the key actors, including President Martins and Lord Russell, who can barely be accused of bias towards Venezuela. They are contemporary. Russell, Martins, and Mallet-Prévost all went on record in October 1899. Their accounts completely undermine Guyana's attempt on Monday to dismiss Venezuela's claims as the fantasy of an aging man, written up decades later. And perhaps most importantly, on the essential question, how did the tribunal reach its decision, these authoritative contemporary accounts converge. There is no trace of any legal consideration that could explain where and how President Martin's compromise line was drawn. Arbitrators Collins, Russell, Brewer, and Fuller, they did not yield to the force of a stronger or any legal argument. No one even pretended that. They yielded to threats. Threats that are described with clarity and with specificity. Threats that forced the tribunal's members into accepting a deal that had no basis in legal reasoning. Paul Reuter was right. This was horse trading. This was un marchandage purement politique. Mr. President, members of the court, looking at the evidence before you, it is clear that in rendering the award of 1899, the tribunal plainly did not conform to the terms by which the parties had defined its task. It deviated from these terms in multiple, glaring ways. The Tribunal ignored one of the questions put to it. It decided an important matter not submitted to it. It fails in its solemn duty to render a decision based on law. And of course, as Professor Palchetti has shown, its decision was based on an invalid treaty and failed to give reasons. Each of these grounds, looked at in its own right, would be a ground of invalidity. Taken together, they lead to one inescapable conclusion: this award is invalid. And yet, Mr. President, members of the court, as I conclude, permit me to return to Venezuela's central contention in this case. Ultimately, we submit you need not decide between validity and invalidity. While Guyana asks you to declare valid an award that is plainly indefensible, it fails to accept the wisdom of the Geneva Agreement on which this case is based. As my colleagues have shown, with the Geneva Agreement, the parties left behind their debates about an award tainted by glaring defects. An award that was as painful for Venezuela, its victim, as it had become embarrassing for the United Kingdom, its supposed victor. In light of the arguments you heard about the question of invalidity, we ask, is it not plain that the parties wanted to move on? Venezuela's written pleadings in this case, as well as Professor Palchetti's pleading and mine today, show that the award of 1899 is invalid. But more fundamentally, they help understand why the parties in the Geneva Agreement settled on a framework that would foster a negotiated and equitable settlement of the territorial controversy. This, Mr. President, members of the court, concludes my presentation. I thank you for your kind attention and the extra time you have allocated to me. I would ask you to give the floor to Professor Jean-Marc Touvenin, but this will no doubt be after the coffee break. Thank you.
I thank Professor Tams for his statement. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended.
La Cour.
Please be seated. The sitting is resumed. If you don't mind.
I now give the floor to Professor Jean-Marc Touvenin. You have the floor. Thank you, Mr. President. Mr. President, members of the court, it's an honor to appear before you to present some of Venezuela's views. Mr. President, Guyana basically contends that Venezuela's conduct following the 1899 arbitral award implies that it had waived its rights to invoke the award's invalidity. By doing so, it persists in acting as if the Geneva Agreement had never entered into force, or as if its signatories had agreed in concluding this agreement that a mutually satisfactory solution for the practical resolution of this controversy that was acceptable to both parties was to hold against Venezuela a supposed waiver of its rights to invoke the invalidity of the award, which is, of course, absurd. Unfortunately for Guyana, and this will be my first point, is that the Geneva Agreement is in force, and the controversy which its raison d'etre has never focused on Venezuela's conduct since 1899 and its eventual legal consequences. I might even add that even if the Geneva Agreement didn't exist, quod non, Guyana's theory, from which it would follow that the defects of the arbitral award are cured by Venezuela's conduct, has no evidence. This will be my second point. And finally, and in any event, Venezuela asserted
Richard Olney, Lord Salisbury, Joseph Chamberlain, David Brewer, David Gilman, Severo Malley-Prevost, and others. In light of this recently discovered and compiled evidence, Venezuela has conclusive proof that it sustained a non-pecuniary and legal loss when it was deceived and deprived of its legitimate territory by the 1899 award. Fin de citation.
End of quote. Already in 1951, Venezuela, in fact, announced that it would challenge the 1899 award during a meeting of the Organization of American States. The Venezuelan representative then announced solemnly that Venezuela claimed a reparation of damages caused by the 1899 arbitration. In 1954, during the Inter-American Conference, the state representative declared that owing to special circumstances prevailing at the time of the 1899 award, Venezuela expressly reserved its right that it definitely did not waive to ensure that the boundary resulting from the award would be rectified. In 1960, a member of the Venezuelan Congress shared the same view, and lastly, in 1962, Venezuela presented its claim before the United Nations, which led to the Geneva Agreement. Mr. President, it is undeniable that it was indeed when Venezuela obtained positive evidence, definite and conclusive evidence to cite Professor William Cullen Dennis that the 1899 award was null and void, that it was able to envisage invoking it and that it availed itself of that possibility. It was only then that it was entitled to do so, a right which it had never waived or been able to waive. That, in fact, brings me to the end of my pleading. And as I do not have enough time to dwell on this any further, I would now like to conclude today's pleadings. Mr. President, members of the court, the presentation made by Venezuela today concerns the Geneva Agreement signed in February 1966. This agreement notes the disagreement amongst the signatories concerning the arbitral award and requires them, under a new treaty obligation, to seek practical and mutually acceptable solutions for its parties in order to resolve the controversy amicably. Venezuela firmly rejects the contention redolent of colonial paternalism that this agreement is a trap, that Venezuela, suddenly afflicted by instinctive, emotional and thoughtless schizophrenia, would have set itself a trap. Yet this is what was suggested with complacency on Monday. Already in 1962, it was also said Venezuela knew quite well that it couldn't claim the invalidity of the 1899 award, already in 1962. And then why did it enter into the Geneva Agreement 4 years later? If we believe Guyana, the 1966 agreement is nothing more than an agreement to bring the matter before the court. And Venezuela has always said that that was not the case. Besides, if it were the case, that would mean that in signing the Geneva Agreement, Venezuela's only objective would have been to bring before the court a claim which it knew from the outset was doomed to fail. And in signing the Geneva Agreement, it deliberately abandoned its stance with regard to the invalidity of the award whilst pretending to assert it. This is both absurd and flies in the face of reality. And if it's not to set a trap for itself, what is suggested by Guyana, and if by signing the Geneva Agreement, Venezuela thought that it had entered into a treaty whose purpose and object was to redress the historical injustice which led to its conclusion, in reality, it was quite simply tricked. I don't know whether we can translate this rouler dans la farine into English. So that is the little tune we heard on Monday, with La Fontaine humming in the background. Even the most cunning ruse can backfire on its inventor, and treachery often comes back to haunt its perpetrator. But I will put aside La Fontaine and refrain from dwelling on nursery rhymes, etc., because in fact the controversy which the Geneva Agreement attempts to address is in no way light-hearted. As we know, this controversy, in fact, is rooted in a vulgar colonial scam under the guise of an arbitration purportedly well-founded in law. The story is well known, it's unquestionable. Throughout the 19th century, the British embarked on aggressive colonization of the Venezuelan territory, hotly sought after for its gold deposits, and Schomburg was a docile instrument of this. None of the purportedly legal arguments put forward by the British Crown in order to justify the successive annexations were founded in the slightest way. Besides, that's why the British objected as long as they could to the very idea of arbitration based on the law at the time. In that respect, when in 1886 Sir Hertzlet, member of the Foreign Office, was called on to evaluate the legal basis of the British claim, he opined, "It's a poor one." His opinion was frank because it was given in confidence, and it was that the British Empire, and I quote,
to arbitration with the slightest hope of success, given the contradictory claims which have been put forward in the English published maps. Il ajoutait,
And he added, the arguments based on grounds of strict right would be hopeless. End of quote. Aware of the legal nonsense of their claims, the British at first only accepted to go to arbitration under certain conditions. Secretary of State Olney, in a letter to Bayard dated July 1895, summarized the British position in the following terms.
Venezuela can get none of the debatable land by force because you are not strong enough. You, Venezuela, can get nothing by treaty because I, Great Britain, will not agree. And you can take your chance of getting a portion by arbitration only if you first agree to abandon to me such other portion as I may designate. Olney ajoutait, it seems therefore quite impossible that this position of Great Britain should be assented by the United States, or that, if such position be adhered to, with the result of enlarging the bounds of British Guyana, it should not be regarded as a mountain in substance.
Put forward, if the British invasion and conquest of the Venezuelan territory could be validated through arbitration, the usurpation of territory would be acceptable for the United States. In order to impel the English to accept it to enter Act, it was seen that a finding adverse to Great Britain would produce an awkward situation. Hence, the drawing up of an arbitration treaty negotiated behind the back of Venezuela, with the same Olney as the one just mentioned at the helm, inventing and recording together with British non-existent rules nipping in the bud Venezuela's best legal arguments. The fraudulent nature of this arbitration treaty is exemplary. It's impossible to find a finer specimen. You would have to be taught in the legal faculties. The arbitration itself proved to be a farce in very poor taste, and in that respect, Olney, in a letter sent to Cleveland on the 27th of December 1899, was not in the least concerned by the loss of territory to Venezuela, which he had been one of the secret artisans of during the negotiation of the arbitration treaty, but only bewailed the general discrediting of the cause of arbitration. That was his only concern. Men of law, for their part, were appalled, and he wrote,
Both the Chief Justice and Brewer are down on arbitration as a mode of settling international disputes.
from the arbitrators, it only bears its name and is no less, as Harrison wrote, the theft of a vast expanse of Venezuelan territory, the one coveted by the British because of the gold mines. In the face of the mystification of this 1899 arbitral award, Venezuela could simply just note betrayal and disaster. For want of evidence of its invalidity, and only having at the beginning a few clues, namely the brevity of the deliberations, incompatible with the complexity of the case file, as regards what occurred. No evidence. With regard to the British Empire, it remained dangerous for Venezuela as it had been throughout the 19th century. The blockade at the beginning of the following century, in fact, serves as a reminder of that. In that context, whereas it had expected both justice and protection from arbitration, it just made do, for want of justice, to apply the award as a shield against any further attempts of expansion by its powerful neighbor. And the Malais-Prévost memorandum changed the course of unsaid motivations, but in fact there were no reasons. The award was simply the result of extortion, quite simply on the part of the president of the tribunal, eager for personal glory, which he placed in achieving a unanimous to inevitably trap poor Venezuela, decidedly very innocent, was, on the contrary, a treaty which was entered into in good faith during a key period of the 20th century, no doubt one of the most important, that of decolonization. It was concluded in order to put to an end a historical injustice, this colonial monstrosity to be found in this so-called arbitration. Through this Geneva Agreement, the signatories, in fact, undertook that any need to be recalled was always that through this agreement, it never, in fact, intended either explicitly or implicitly to recognize the jurisdiction of the ICJ in any way. That was its position and remains so. It considers that the court does not have jurisdiction to entertain Guyana's application. That's why this morning there was only the agreement that was aggressed. In fact, Venezuela is acting under international law, as is fitting in its relations with Guyana. And indeed, it's the Geneva Agreement which is historical because it opened a new chapter in relations between the two states with regard to the territorial and historical controversy between Venezuela and the United Kingdom since the middle of the 19th century, and which Guyana then took over. I repeat, Guyana good faith for a flagrant injustice, the usurpation of the Venezuelan territory, victim of the British greed, be resolved in a satisfactory manner between its or for its signatories, on the one hand Venezuela and Guyana, freed of British colonization. This brings Venezuela's presentation to the end. Thank you for your attention.
I thank Professor Tubanen. Statement bring with Guyana, the second round of oral argument. The sitting is closed.
you.